Today we're going to talk all about work permits. I recently had a conversation with an employer who's trying to help his employee out, and this employee happens to be undocumented. And the conversation went something like this. I want to help my employee out. He's been here for like 20 years. He speaks English. He has US citizen kids. He files his tax returns, and he's never had problems with the police. I can just petition for him and help him out, right? Actually, it's a bit more complicated than that. And no, you can't fix someone's status through an employment petition if they've been here unlawfully. Today, we're going to talk about some employment authorization categories that people can use to apply for work permits and some do's and don'ts and scams to watch out for in this space. Sitting in front of me is a list of 56 categories which you can use to apply for employment authorization, also known as a work permit or EAD. For the purposes of this video, I'm referring to the same work permit document when I use any of these phrases. On this list, there are some categories which are more common than others. Specifically, people who are applying for asylum, have asylum pending or asylum granted, are eligible for work permits. People who have applied for temporary protected status or DACA can get work permits. Anyone who applies for a green card, has adjustment of status pending, can also apply for a work permit and get it while the green card application is processing as a temporary benefit. Now, there are other categories too. For example, if you're here on certain visas, you're eligible for a work permit. Common examples are student visas, fiance visas, and in some situations, U visas for people who are here and are victims of certain crimes and are applying for a U visa. One of the common themes throughout these work permit categories, which doesn't apply to every category but applies to most categories, is that you have to be applying for some other benefit. And typically, along with that other benefit, you can apply for the EAD or work permit as an ancillary benefit. So that's one of the main things to keep in mind. You can't just apply for a work permit out of the blue because you've been here for 10 years or because you've been filing taxes or have US citizen children. This is a very common misconception. You need an actual basis to apply for the EAD. So what I want to talk about next is a common situation that people accidentally find themselves in, which is a huge problem and which may have consequences for people who are desperately trying to get EADs. Now, there are some people who believe that if you've been in the United States for longer than 10 years and you have US citizen children, you might be eligible for a work permit. This is kind of true, but mostly not true. And let me explain why. Okay, the way that this usually works is somebody's been here for a long time and they see that some of their friends who've also been here for a very long time out of nowhere have recently received work permits. And they go and talk to the person who helped them apply for the work permit, and they are told that they can also apply for a work permit because they've been here for longer than 10 years. Now, let me explain what that process actually looks like, because a lot of people who apply for these work permits don't understand what they're actually doing. So oftentimes, what happens is this person will willingly or unwillingly, unknowingly, accidentally apply for asylum after they've been here for more than 10 years. You're not eligible for asylum under most circumstances. If you've been here for 10 years and haven't applied yet, you usually need to apply for asylum within your first year of entering the US. But nevertheless, some people will apply, and they'll apply way too late and they'll get a work permit out of it. If you apply for asylum and your application for asylum is pending for longer than 1 year, you can apply for employment authorization. And oftentimes, your asylum application won't be adjudicated or reviewed or decided in any way for years. Oftentimes, 5-10 years down the road, your case is still pending. During all this time, you were able to renew your work permit. But what people oftentimes don't understand is that eventually that asylum application will get adjudicated. You'll get called into the asylum office for an interview. You'll probably be referred to immigration court after the asylum office determines that you're not eligible for asylum. And now the process of removal proceedings or deportation proceedings begins. At this point, you might be eligible for some defenses from deportation. But understand that if you are not eligible or your case is denied, you'll go from having renewed your work permit for the last 5 or whatever years to a full deportation order. A lot of people don't understand that the work permit was just a temporary benefit and that eventually the case will get decided. Now we are down the road and you are in immigration court. You might be eligible for a defense from deportation called cancellation of removal, and this requires proving a few different things. That you've been here for longer than 10 years, that you've been a person of good moral character, and that you have a qualifying relative, oftentimes a US citizen child, who will suffer extreme hardship if you are deported from the United States. Extreme hardship in this context means that they will suffer more than a normal child who is losing his or her parent to deportation. It's a very high burden. Most people do not qualify for this. By definition, most people don't qualify because it's extreme and unusual hardship. And that means that needs to be more hardship than a normal person will experience. If your child will not suffer more than a normal child who's losing their parent to deportation, or you just get an unfavorable judge who's hostile towards these cases, you'll go from having renewed your work permit and starting to live a normal life in the US to a deportation order. So it's super risky to apply for asylum if you've been here for longer than a year under these circumstances in most situations. If you're thinking about applying for a work permit, what should you do? Okay, the first thing you should do is actually speak with a lawyer, preferably a lawyer who focuses their practice on immigration law. If you spoke with me and said, hey, I've been here for a while, haven't had immigration status, I had contact with immigration when I entered, or I entered without any, contact or problems with immigration, what I would do is screen you. I would go through a bunch of the categories and see if you qualify for a work permit in a way that doesn't create additional risks for you. What I see happen and want to warn you against is people who speak to notarios or paralegals or people who just know how to apply for asylum, because that's the most common thing I see. I see people in immigrant communities going to someone in their community who they trust, who's helped a lot of people get work permits. And once I understand what's actually happening, I realize all this person did was submit an asylum application for all these people and then just waited and then applied for work permits for all these people. And the dominoes haven't started to fall yet. And unfortunately, a lot of those people are going to end up with removal proceedings at the end of the day. Your main takeaway from this video should really be that if you've been here unlawfully for years and you see an opportunity for a work permit, you should ask a lot of questions because it might and probably is in most situations too good to be true. Not always, but usually in my experience. If you're wondering whether you qualify for a work permit, I'm always available to assist or consult regarding this. Also, check out my video about immigration options if you're here legally or after you've overstayed your visa. Again, guys, I'm Puyan Darian, here to give you all the info on immigration law, and I'll see you next time for my next video.